Our first case to come before the court this morning is State versus Dabney, and I understand that the state is just arguing as the appellant today, and the other side has not filed a brief and will not be presenting an argument. Just to remind you, you'll have 15 minutes completely, and please don't use the name of victims or children because we are recording everything that will be on our YouTube channel. I will be watching the time and just, well, you don't have to remind me again. So I still want to tell you that, we're reserved 5 minutes. So I'll be watching time. I'll tell you when you're 15 minutes. Is that
Sure.
Okay. And just stand behind the podium, please.
Sure.
Thank you.
Good morning, Your Honors. Lindsay Poprocki on behalf of the state. This is a state's appeal from the trial court's decision to grant a motion of Samuel Dabney filed pro se to vacate his plea post-sentence. The state submits that the trial court's decision to do so, the trial court did so and abused its discretion in two ways, either of which support reversal in this case. First, the trial court granted Dabney's motion to vacate his plea absent the required showing of a manifest injustice. Second, the trial court impermissibly entertained Dabney's motion filed pro se while he was simultaneously being represented by counsel. And I'm not going to belabor the facts in this case because I know that the court has read my brief, but at the outset I would note that as a consequence of failing to file a brief in this matter, that the appellee, that this court may accept the state's statement of facts, and I would ask as correct, and I would ask that the court do so. And a showing of the manifest injustice is characterized by a flaw in the plea proceedings, which results in a miscarriage of justice, and it is required to vacate a guilty plea post-sentence. It's an extremely high standard to meet, and Dabney failed to demonstrate a manifest injustice in the plea proceedings. In fact, when Dabney moved to vacate his plea, he did nothing more than profess his innocence for the first time and complain about the restitution order that was ordered to be paid upon his sentence.
Counsel, this was a plea agreement, right?
Correct.
And he was actually charged originally with felony.
Arson, correct.
But I couldn't remember exactly, but felony charges. And then they were then reduced to misdemeanors.
Correct.
So in the court vacating the plea, all bets are off, right?
Correct.
Or it could be felony again.
Correct.
Okay.
It's returned to the trial court for further proceedings, which has been done. He's vacated the plea and the sentence.
Okay. I was just wondering about that.
Sure. The record reflects that Dabney's plea was entered into knowingly, voluntarily, intelligently, and the stated grounds for to support a manifest injustice do not justify the withdrawal of a guilty plea where the defendant's motion reflects a mere change of heart. Courts have stated that for a defendant to claim innocence, a defendant's claims of innocence, no matter how frequently claimed, are not sufficient to vacate a guilty plea that was knowingly, voluntarily, and intelligently made. A mere change of heart regarding a guilty plea and sentence are insufficient justifications for the withdrawal of guilty plea. Instead, when faced with a claim of innocence, the trial judge must determine whether that claim is anything more than a defendant's change of heart. In this case, there is no indication that Dabney made anything less than a knowing, involuntarily, intelligent plea. The record reflects as such. During the plea colloquy, the trial court individually outlined the amended charge to which Dabney would plead and the maximum penalties he faced, and it indicated that he would be subject to the restitution order. The trial court further advised Dabney that the court and restitution order that could be imposed, and he informed Dabney of the rights that he would be waiving by entering the plea. Dabney acknowledged his understanding of each of those advisements and entered the guilty plea. The court also reviewed the plea sheets with Dabney, and he acknowledged that he assigned those forms voluntarily after consulting with counsel who he advised that he was always satisfied with. When considering Dabney's arguments to vacate his plea, which included a claim that he could not be guilty for criminal damaging for removing stuff from his own property, the trial court noted itself that he had made no claims of actual innocence or claim of inducement by counsel during his plea hearing, but rather entered the plea voluntarily upon his own accord. Dabney's own admission that he cannot pay, and further, Dabney's own admission during the motion hearing on his motion to withdraw the plea that he cannot pay the money that was ordered as restitution, and the timing of the motion, which followed almost immediately after the state sought to impose the jail sentence, further suggests that his motivation to withdraw the plea was merely a change of heart. In this way, this case is in line with State v. Meade, which was cited in the state's brief, where the court affirmed a decision of a decision of the trial court to reject a defendant's motion to withdraw his guilty plea because the defendant's displeasure with his plea was likely based on his reflection that he didn't like the restitution order that had been placed by the court. Ultimately, Dabney's change of heart regarding his plea did not amount to a manifest injustice, and the trial court's decision to grant it was an abuse of discretion. As a second ground for reversal, the state maintains that the record reflects that the trial court impermissibly allowed hybrid representation. Throughout the proceedings, Dabney was represented by court-appointed counsel. After sentencing, Dabney continued to be represented by counsel, who was ordered to appear at review hearings and did attend those hearings. While represented by counsel, Dabney unilaterally filed a pro se motion to vacate his plea. At the June 12, 2024 review hearing, counsel advised that Dabney's motion was filed pro se, yet the trial court itself asked counsel, after being advised that the motion was pro se, to advise Dabney on the standard required to be met on a post-sentence motion to withdraw plea. Counsel was sent outside the courtroom, and it appears that he in fact advised Dabney on that standard because Dabney then supplemented a motion citing that exact standard of manifest injustice.
Counsel, I know the case law provides that if you're represented by an attorney and you file pro se, the court may not look at the pleadings or the motions or whatever. But does that mean it's discretionary, or does that mean it's mandatory? In other words, the court can exercise its discretion to not look at it, or it just doesn't have the power.
I would indicate that it's impermissible. I think we cited as our assignment of error that was an abuse of discretion because the assignment of error is that the court abused discretion in granting the motion to withdraw his guilty plea, but I would say that the hybrid representation, it's impermissible to allow for the court to entertain those motions.
So when the case law says may, what they mean is you cannot.
I believe so.
Thank you.
So we would say that the state would submit that the trial court erred in allowing the hybrid representation, and that based on either of the grounds advanced, the state submits that the trial court's decision to grant Dabney's motion to withdraw his guilty plea should be reversed.
Thank you. Thank you. Thank you so much. You, as you know, since you've been here many times, we will take the matter under advisement, and we'll send a written opinion out to parties, as well as releasing it on the Supreme Court website. So thank you.